So I'm going to try to make it as quick as possible, but it is a little complex and
Yes,
a lot
please.
of legalese. In essence, we picked a jury back in December 11th through December 13th of 2023. At that point, we had demanded a speedy trial, which means that my client is entitled by statute to be tried the term they asked for a trial or the next following term. And if they're not tried by then they should be acquitted. Problem was that the previous judge got us to pick a jury at a timely fashion and then took a 28-day break to come back. I thought that was wrong. I appealed that. I went to the Court of Appeals and I said, the mere act of picking the jury is not enough. Sadly, they disagreed with me and they sent it back. But when they sent it back, what they said, because it's been so long, there's no way you can go forward, especially because the court had closed jury selection to the public. Y'all weren't allowed to be there. Everybody that wanted to be there, members of the community, family, the media, the public, which have a right to be in court because that's guaranteed by the Constitution, were not allowed to be there during jury selection. I also said that was basis for an acquittal. The Court of Appeals disagreed on the speedy point, but agreed that the court should have never been closed. So then we're back here. What the Court of Appeals said, because the courtroom was closed, you need to start over. What we said is like, no, hold on. I want an open public trial, but I want this jury more than that. These jurors that we spent 3 days picking, thinking about, talking to them, those were our jurors. And I just rode the shuttle with them. They're no longer in the jury, so they had a chance to talk to me. Mm-hmm. They were very supportive of what was of our case.
They were ready to do it.
Yeah. They were ready to. They wanted to do it immediately. They were more upset about the delay.
And they hadn't been in the courtroom in 16 months. Is that correct?
18. I think 18 months. Again, we're going back to December of 2023.
So they've been just sitting around waiting, going through a circus.
One of the jurors said, "We should get paid for every day we were out there having to abide by these rules of not talking to family about the news." Because this is national news, it's international news, and they're not even allowed to watch social media. This is how people live nowadays. You get all your information on social media, but as soon as something comes up, I gotta shut it down. I can't watch my TV shows. I can't interact with my family. I can't have conversations with my loved ones because a court told me I'm not allowed to for the past 16 to 18 months. So anyway, we picked that jury. That's the jury we wanted. So when we got here today, and we're told, the Court of Appeals says we got to get rid of this jury. We said, you know what? We are waiving that objection to the voir dire openness, and we want to keep this jury, and we want to go forward with the jury. The court disagreed with me. The court says, no, I have to follow the Court of Appeals, and I have to dismiss the jury, and that's what I'm appealing right now. What I'm appealing right now is that my client has already been placed in jeopardy once, and the Constitution guarantees that you cannot be placed in jeopardy twice. It's in the very first document for this great nation, the U.S. Constitution. Not only that, also the Georgia Constitution guarantees that you shall not be placed in jeopardy more than once.
And how has your client been placed in jeopardy?
Jeopardy attached when we swore that jury. That's when we were ready to go to trial, and that is the jury we chose. By dismissing the jury, our argument is now they're going to be placed in jeopardy again, and that's double jeopardy. And it's not one of the, that's where it gets very technical, it's not one of the very few instances where it's okay to do a retrial. For example, if there had to be a hung jury when 12 members of the jury cannot have a unanimous decision as to guilt or innocence, and one is either saying guilty and 11 not guilty or vice versa, that's a hung jury, and that results in a mistrial. What happens? You get tried again. Because when there's a mistrial, the state has a right to proceed. Many times they don't. Many times they do what? You know what? We couldn't convince 12 people, so let me give you a better offer. An offer that's too good for you to say no to. And that's usually how negotiations work. But in this case, that's not the type of mistrial we're talking about. The type of mistrial I'm objecting to is a mistrial where you got rid of the juries that we picked and that we wanted. My client wanted that jury, and that's what we're going to go up to the Court of Appeals for.
And what is next at this point in time? I know it's hard, but paint a timeline for me.
We are hoping as soon as the order is signed, we will appeal, and then the Court of Appeals should docket it and give us a response. It might be given to us purely on the briefs that we're going to submit, or we might have oral argument one more time. But that's what we're waiting on. We're waiting to see, once the judge signs the denial, then we will be able to appeal, and then the Court of Appeals will make a decision, and we'll determine whether or not we want to go forward as the whatever decision they take. We might even go forward to the Supreme Court.
And lastly, what did it mean to see all of these folks here supporting your client right outside of the courthouse?
All of these folks here are not only supporting my client, they're supporting freedom of speech. They're supporting everybody's right to be able to stand up to the government and say, we don't agree with what you're doing. You want to spend millions of dollars in a cop city? We don't want that. Give it to us. Put it on a ballot. Let's vote on this. And when that's denied from the people, they stand up and they protest. Like this is quintessential part of American history. If you don't like something, you throw the tea on a boat. And you know what? Tossing tea over the side of a boat, that is property damage. But property damage is not violence. When somebody tags something, when somebody breaks a window, that's not violence. What's violent is the police response. When somebody's camping out in the forest because they object to a cop city being built, a forest being destroyed, and millions of dollars being wasted, it should not be justification to come murder that young man. And that's really what these people are here to say. We will not die just because the government doesn't like what we have to say.
Gotcha. Well, thank you so much.
Say your name. Are you filing interlocutory or a direct appeal?
This is a direct appeal. This because it is a case that would end up in resolving the case one way or another. We have a right to a direct appeal.
And then just for clarity, would it be accurate to say that you're appealing the mistrial on the grounds of double jeopardy?
We're appealing a retrial because on the grounds of double jeopardy, statutory double jeopardy. My client has already been placed in jeopardy, and this is not one of the very few exceptions, according to our reading of the law, where the state gets to get a do-over. Because they already had a chance to go forward. And we said we want this jury, and the state said no. The state wanted a mistrial. Why? They never put it on the record. We never had a hearing, asked for the state to be able to present arguments as to why do you want a mistrial so bad? What is wrong with this great group of people, citizens of Georgia, that have already been selected to make a decision as to whether or not my client is guilty? That's what we were fighting. Why does the state not like these 12 members of the community?
All right, thank you so much.
course.
Appreciate it.
Another technical point. What about Fowler's statement that the Constitution says exceptions include when a mistrial is done?
Great thing about Mr. Fowler, he's very smart and he knows exactly what to quote in the Constitution. He's right. That's what the Constitution says. But the statutory double jeopardy gives us even more protection than the Constitution, because that's what a Constitution is. It is the floor. You have rights guaranteed to you by the founding fathers as the floor. And then when the legislature starts looking at things, they can beefing up those rights. You can't go below that, but you can always make them stronger. And that is our argument that we're going to be taking up to the Court of Appeals, that the Georgia statute for double jeopardy gives us even more protections. And actually, we do believe that the Constitution also goes with our argument that my client should be acquitted.